We will keep fighting, and I assure you we didn't win today, but we will win.
Donald Trump's attorney, Alina Habba, came out swinging last Friday after the jury delivered a staggering verdict of $83.3 million against the former president in advice columnist E. Jean Carroll's defamation suit.
We will immediately appeal. We will set aside that ridiculous jury. And I just want to remind you all of one thing. I will continue with President Trump to fight for everybody's First Amendment right to speak.
But in order to appeal the verdict, Trump has to put up money equal to the judgment with cash or a bond to maintain the status quo during the appellate process. And with the probability of yet another verdict this week in a case where the New York Attorney General is asking for $370 million, Trump might have to put up close to $500 million in order to appeal both verdicts.
I have made billions of dollars in business-making deals.
Of course, Trump has always bragged about his wealth, and under oath in a deposition in the New York Attorney General's case, he described his stockpile of cash as being substantially in excess of $400 million. Joining me is Bloomberg legal reporter Erik Larson, who's covered both Trump trials. So, Erik, Donald Trump's lawyer, Alina Habba, is floating the idea already of a new trial in E. Jean Carroll's defamation suit. What is she saying? What are her grounds there?
Well, she says that she read in a New York Post article after the verdict came down that E. Jean Carroll's lawyer, Roberta Kaplan, and Judge Lewis Kaplan had worked at the same law firm, Paul Weiss, over 30 years ago. And as the article described, it was a mentor-type relationship. And it quoted, an unnamed lawyer there to say this. And so then Alina Habba wrote a letter to the judge raising this article and raising this question and seeking more information and suggesting that it could be used in seeking a new trial or on appeal and, raising questions about this supposed professional relationship.
So what was Roberta Kaplan's response? And we should say that she's no relation to Judge Kaplan.
So Roberta Kaplan filed her own letter to the court responding today, saying that this is all hogwash, saying directly to the judge, yes, we did overlap for less than 2 years at Paul Weiss. He was a senior litigation partner. She was a litigation associate. She started working there in, I think, 92, and he left in 94 to become a judge. So she said that she doesn't remember working with him on any case, that there was no close, mentor-type relationship with him. She said that she does recall specific partners from that period in her life at the firm that she thinks of that way and that he's not one of them. And she said that this was such a, frivolous argument for Alina Habba to raise in this letter, making it public in this way, that she would consider seeking sanctions and really trying to shut this down. And I should probably note that just before we came here to do this recording, Alina Habba filed another letter responding and basically said, essentially backed off and said, well, now that I have this response, this sort of answers the question. I guess this is done. It's resolved.
So a tempest in a teapot. That's the fastest anything has been resolved in this trial. Right. I want to get your take on Habba's clashes with the judge during the trial, because they were frequent and often hostile. And what struck me in particular is that Habba, who's not an experienced trial attorney, fought about what evidence could be admitted with this highly respected federal judge who's been on the bench decades, making these rulings about evidence in everything from terrorist trials to Sam Bankman-Fried's trial.
Well, first of all, Judge Kaplan is known for being pretty no-nonsense. He doesn't want to take anything from any gruff from anyone. And if he makes a decision and says it's final, he doesn't want anyone going beyond that. And, of course, he's very strict about his rules in court. Trump's campaign spokesman, Kevin Chung, was kicked out of the trial when his phone went off So anyway, on the last day of trial, before the jury came in, the judge was having some last-minute arguments about the closing arguments, what they were going to show the jury. And the defense was upset that a certain slide was being ordered out of the closing arguments. It was a compilation of different tweets that they said made their argument that E. Jean Carroll was attacked before Trump issued these defamatory statements. So anyway, the judge said, no, these aren't properly in evidence. You're not going to use this. This slide is out, period, done. And she got up and said, I have to say something. And the judge said, no, you won't. You're very close to me spending some time in the lockup, Ms. Haba. Sit down.
And she did.
And she did. And she and Trump looked at each other, and they were clearly fuming, and they were not happy.
Going to the verdict, and it's sort of unusual to me because usually by this time in a case like this, a high-profile case, you hear from one or two of the jurors. They decide to talk about what they've done. In this case, they've been as silent as Trump has been about the verdict, another astonishing fact. So I guess they took the judge's advice.
Right. Well, so this was a rare anonymous jury to begin with. So because of the risk of essentially Trump supporters threatening these jurors, the judge said that it would be an anonymous jury, sort of the thing you might expect from like a mafia case or something like that, or a terrorism case. But of course, during the voir dire process and jury questioning, they took certain steps to prevent people like us, reporters, from being able to piece together who they were. But after the trial was over and before he dismissed the jury, he said, you are now free to identify yourselves to the public. What you can't do is identify each other. He's like, do not tell anyone about your fellow jurors. And he's like, and if you want my advice, never, ever tell anyone you were involved in this case.
It's sort of chilling to hear that warning from a federal judge. Now, Trump is going to appeal both of the E. Jean Carroll verdicts. So that entails more than just putting papers into the court. You have to put up money equal to the judgment amount through cash or a bond. So what did he do in regard to the first Carroll case where the award was $5 million?
He put up $5.5 million in cash. So, I was told by his lawyer in that trial, Joe Tacopina, that it was simply a matter of money. It's cheaper to put up your own cash than to use a bondsman where you're paying to use someone else's cash. So Trump obviously is known to have hundreds of millions of dollars in cash. I think even the Bloomberg Billionaires Index own estimation of Trump's net wealth of $3.1 billion includes $600 million in liquid assets. And as we know, Trump testified under oath that he has more than $400 million in cash. So I would expect him to put up cash for this appeal.
That is a lot of cash. But you think he won't put up an appeal bond because he'd lose money on it?
I mean, I'm just going off of what he did in the last trial, where he would look at, if you have the money, why pay to use someone else's money? Because either way, if he loses, he's going to have to pay that money. So I guess if I had the money, I would. But
he's been fundraising off his legal troubles for some time.
My understanding is that he does raise millions of dollars for his campaign, right? This is for money that's not necessarily being used for his defense, but he has been using money for legal expenses, because if a candidate can show that, a case is related to something having to do with his candidacy or his presidency, in this case, as some of these cases do, that he could use some of that money for legal fees. I don't know that would translate into this E. Jean Carroll case or even the New York Attorney General civil fraud case, but he does also have PACs, these super political action committees. Those are not supposed to coordinate in any way with a candidate, though. It's unclear. It's such a gray area from these experts I talk to. I'm not an expert on those, but the experts I do talk to say that it's a real gray area, that the Federal Election Commission does not do a lot of enforcement in this area, and that, if anything, they sort of chipped away a little bit at enforcement. Seem to be.
So then obviously the damages can't be paid from that. Not that any of these funds have enough money to cover these damages.
We know that the Attorney General is seeking $370 million in this civil fraud case, plus interest, which could put it over $400 million, honestly. And then you add on the E. Jean Carroll verdict. It's a huge amount of money. And even if he were able to somehow use donated money for that, that's money that is now being taken away from his effort to be elected. And also, it might be a little bit more of a difficult sell, potentially, to donors who are donating to a campaign or a cause. MAGA is a lot more than Trump's legal troubles, right?
Some days it doesn't seem like that, but as you mentioned, the Bloomberg Billionaires Index has him at a net worth of $3.1 billion, and that's the most cash and least leverage than at any point in the past decade. So his assets, as you've written about, have been appreciating.
Yeah, I mean, there's no question that he has some very valuable assets, that they've been appreciating, and that he's a very wealthy man. In fact, that's exactly the argument that E. Jean Carroll was making to try to get the jury to hit him with a significant punitive damages award, which it did. So, there's no suggestion that Trump is going to be going broke here. And in fact, in the last few years alone, since this lawsuit was, filed, the New York lawsuit, his assets have gone up almost $500 million. So he was, at around 2.5, 2.6, and now 3.1. That it shot up, since his presidency. So he's done very well for himself. And even though the New York State lawsuit accuses him of inflating his assets wildly for years, as much as $3.6 billion a year, he actually does have money regardless of that. But the point of the New York case is that he was able to get much lower interest rates on hundreds of millions of dollars in loans for over a decade by saying that he was worth way more than he actually was, even if he did have money.
And we'll be waiting for the judge's decision in the New York fraud trial. He promised he would try to get it in by January 31st, tomorrow. Thanks so much, Erik. That's Bloomberg legal reporter Erik Larson. Coming up next, the estate of George Carlin is suing over a comedy special purporting to be an AI-generated impression of the late comedian. I'm June Grasso, and you're listening to Bloomberg.
Thank you. I'd like to start off with a heartfelt apology. I'm sorry it took me so long to come out with new material, but I do have a pretty good excuse. I was dead.
When podcasters Will Sasso and Chad Kultgen released their hour-long comedy special entitled George Carlin, I'm Glad I'm Dead, they billed it as AI-generated, created by an AI trained on decades of the late comedian's material. So Carlin's estate sued the duo, citing the right of publicity and copyright infringement. But now the podcasters are claiming that, in fact, the special was actually written by a human, one of the podcasters, changing up what's at stake in the lawsuit. If it sounds confusing, it is, but it's happened before. Joining me is Xiyin Tang, a professor at UCLA Law School. Let's start with the first iteration of this, which was supposed to be AI-generated. Tell us about that.
So the claim that was at the center of the complaint was that the comedians Will Sasso and Chad Kultgen had fed thousands of hours of copyrighted material from the comedian, now deceased, George Carlin, into an AI model. And then once that AI model had been trained on all that Carlin material, it was able to spit out or generate a entirely new comedy routine based off of Carlin's jokes.
And in the lawsuit by Carlin's estate, they're making two different claims, one based on copyright and the other on the illegal use of Carlin's name and likeness.
Well, so it would be a copyright claim in the sense that there was a lot of copyrighted content that was fed into the large language model, the LLM, which resulted in a copy of the material being made while the LLM was being trained. So that's one claim. And then the right of publicity claim is based off of the replication of the comedian's voice. Are both claims that have been lodged against AI or generative AI companies for the past year, both on the training data with a number of similar lawsuits, many of them class actions, have been making the same claims with regard to the training of LLMs based on copyrighted books, for example, or copyrighted comedy routines. There's, for example, one currently pending in federal court filed by the comedian Sarah Silverman, representing herself and an entire class of plaintiffs, the complaint alleges, whose material have all been copied into the LLM. And then on the right of publicity claim, there's been similar allegations made against AI, such as the Drake Weekend mashup that went viral a few months ago, in which the AI basically is trained on a celebrity's voice and then is able to generate an entirely new work, a new song, but using that voice.
Now, have any of these lawsuits progressed to the point where there's been a legal opinion about whether this is a violation of copyright?
So no. So there have been some courts that have issued opinions that have basically denied or dismissed certain claims filed by the plaintiffs, but certainly no opinion issued by a court that has definitively answered the question of whether or not the use of copyrighted material as training data for the AIs constitutes copyright infringement, or, and even if it is technically copyright infringement in the sense that there is a copy being made when the material is ingested, whether that copying is protected by the defense of fair use.
You study this, you teach this. What's your opinion?
I think it's a deeply complicated issue. I certainly think that there is a line of cases that have preceded this based on, for example, whether or not it is fair use for Google to scan massive amounts of copyrighted books in order to create their Google Books function, which I think a lot of us use, in which you can search within books and it'll return snippets of, in many cases, copyrighted books. And it's helpful for researchers to be able to search within books, many of which are out of print. Now, those prior decisions have held that such uses are fair, even if they're technical copyright infringements. They're still protected by fair use because they are technologically transformative uses of copyrighted works, because they are using the copyrighted works for a wholly different purpose. I think in this case, similar arguments could certainly be made, and I could see certain judges making that determination based on the transformative nature of what AI does, and the fact that maybe what you would argue is true to the name training data. The LLM, the large language model, is simply learning from the copyrighted material, not to wholly reproduce the copyrighted material on the output side, but instead to create a wholly new transformative work. I think that argument is somewhat complicated by recent lawsuits, including one that has been filed against the New York Times, which alleges that even on the output side, apparently through some prompt engineering that the lawyers for the Times did, what they were able to get the AI to do was to generate entire news articles that replicated word for word New York Times articles that have been published. And so if that's true, then certainly you would say, well, the work that's generated by the AI is a direct infringement. And moreover, maybe even the ingestion of the copyrighted work into the language model is also an infringement that is not protected by fair use, because it is ingested for the purpose of directly competing with the plaintiffs, the authors' income streams, because it is substitutive of the plaintiff's works and is likely to harm the market for plaintiffs' work. And I certainly think that another argument that plaintiffs might use is that currently there are active licensing discussions going on between content holders and AI companies to try to license large amounts of this material for training data purposes. And if that's true, a court might say, pointing to a long line of cases, that this is a licensing market that plaintiffs has typically been able to monetize and are currently monetizing with these licensing agreements that have been entered into. And so therefore, the unpaid for use of all this copyrighted material in training data would constitute a harm to the plaintiff's licensing market, and therefore it's not fair use.
There's a twist to the case because after the lawsuit was filed, a spokeswoman for the podcasters said this was not actually created by AI. Quote, "It's a fictional podcast created by two human beings, Will Sasso and Chad Kultgen. The YouTube video, I'm Glad I'm Dead, was completely written by Chad." So, surprise, surprise, they're saying it's not AI.
Yes. So if that's true, then, of course, if the material was entirely written by Chad and if the voice is just an imitation, then, so focusing first on the copyright claim, so then the copyright claim is gone because you have wholly original material that's been written by the comedian himself. And then on the right of publicity, the voice imitation, the thing that has always complicated this right of publicity claim, even if it were an AI that was actually spitting out George Carlin's voice and not some voice imitation, the right of publicity claim was always complicated by the fact that this is a comedy special. This is an expressive work. And right of publicity claims typically have found that such expressive works are protected by the First Amendment. Right of publicity is slightly different from copyright, but both share this idea, right, that there are certain uses that are defensible, even if we might consider them technical uses of a celebrity's image or technically copying of copyrighted content. So in the right of publicity context, it's clear that the use of a celebrity's image or the use of a celebrity's voice in a commercial is a violation of a celebrity's right of publicity. But when we're talking about something that's an expressive work, like a comedy routine, for example, then most courts have held that that is expression that is protected by the First Amendment, that comedians should be able to, for example, make some commentary about celebrities by imitating them, by maybe even exactly reproducing their voice, by exactly reproducing their image on some type of parody, such as a newspaper parody that uses a celebrity's image. So expressive works get really broad leeway under right of publicity law, and that's why the right of publicity claim is always going to be much harder to vindicate than the copyright claim.
So going back to the copyright claim for a moment, I just want you to explain why you think that there's not a copyright problem if it was written by the comedians themselves, and how artists can look to other artists for inspiration.
Yeah, so copyright law protects the original expression, but it does not protect ideas. And so that's why artists being inspired by other artists has existed since the beginning of time, right? You take an idea that's in some other work. The classic example is the rom-com or something like that. There have been so many rom-coms that have been made.
But I keep watching them.
Same idea. Yes, exactly. And they all contain the sort of same underlying idea about, a star-crossed relationship that then, has a lot of comedic foibles. Eventually the characters end up at the end, right? That's all unprotectable ideas, and folks are free to build off of those ideas and generate their own protectable expression. So, of course, if the claim at issue, assuming that there was no AI in which it had copied large amounts of the actual George Carlin copyrighted content, but assuming that the comedian himself wrote this skit, then even if it's in the style of or the same manner of joke, so long as the expression is wholly different, so long as the comedic routine is not an exact duplication, word for word or very close paraphrasing even of a George Carlin routine, but instead maybe takes the idea of a George Carlin joke and expands upon it, takes the style of his comedic humor and expands upon it, that is all fair game under copyright law. And you wouldn't even need to bring in the fair use doctrine at all. You would just say, I'm only taking the unprotectable ideas. I'm not copying the protectable expression of George Carlin's comedy routines.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with UCLA law professor Xiyin Tang. So why isn't the lawsuit being dropped? Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg. The estate of George Carlin is suing two podcasters over an hour-long comedy special purporting to be an AI-generated impression of the late comedian. Only it turns out the podcasters now say that, in fact, the special was actually written by a human. And that can make a big difference to the claims in the lawsuit. I've been talking to Professor Xiyin Tang of UCLA Law School. So let me ask you this then. The lawsuit argues that the special, quote, has no comedic or creative value absent its self-proclaimed connection with George Carlin, and it doesn't satirize him as a performer or offer an independent critique of society. How does that play into what we've been talking about?
Yeah, so I think they are trying to preempt the argument that this is protected by either copyright's fair use doctrine, which prioritizes transformative work. And of course, remember, this lawsuit was filed back when they thought there was actual copying, at least in the training of the AI portion. And then they're also trying, of course, on the right of publicity front to claim that this is not an expressive work, but is somehow a work that directly capitalizes on an income stream that George Carlin would be entitled to. I think that argument is weak because clearly a comedy special is just not an advertisement for right of publicity purposes. And right of publicity law has been very clear that what it's targeting is advertisements that directly impinge upon a celebrity's right to monetize their image for purposes of selling a product. Now, on the copyright front, the lawsuit was filed with the understanding that the AI had ingested all these large amounts of copyrighted content. So if that's true, then the complaint was trying to preempt the argument that the ingestion of all this copyrighted material was solely to just learn from it for purposes of generating a wholly new transformative work that is a parody of George Carlin's comedy routines. And in fair use doctrine, courts have always privileged these more transformative works that take the underlying copyrighted work and do something different with it. Parodies the copyrighted work, right? Targets the copyrighted work to make a commentary about the copyrighted work. A recent Supreme Court case that was decided last year involving the artist Andy Warhol had said, did Warhol intend to comment upon this photograph that he appropriated and took and created into a silkscreen? The Supreme Court had said no, he didn't intend to comment on it, he didn't intend to parody it, so therefore it's not fair use. So I think some of the language in that complaint is trying to get at the same issues that the Supreme Court was grappling with, which is when they thought that the comedians had actually copied George Carlin's work to create this new work, they wanted to say, you know what, but the new work isn't transformative. It's not commenting upon Carlin's works. It's not satirizing it. It has no transformative purpose. But of course, now that they are claiming that this is wholly original content, then we're in a very different game because, according to them, there was not even copying of any George Carlin copyrighted works because there was no AI that was ingesting large amounts of copyrighted content.
People may wonder, why say it was created by AI? And it's not the first time that companies have been exposed or people have been exposed for masquerading as AI because of the hype about AI. There was supposedly an AI drive-through company, Presto Automation, that touted its automated ordering technology, and filings indicate that it's actually human beings who are powering a majority of the orders. So it's an attempt, I guess, to get a hold of the moment where people are fascinated or repulsed by AI.
Yes, I think it's certainly trying to, as you say, that's one example. The Drake Weekend example, which apparently was actually created by AI, is another one. And I think it's just trying to generate publicity for the stunt and, shock people. And it's always was this actually created by AI? Oh, we're going to actually do a grand reveal a few days later and say, we tricked you, you thought this was AI. actually a human being created it, or vice versa. Of course, I could see stunts saying, oh, this was a human being that wrote this, and then maybe the stunt becomes later that it was generated by AI. Perhaps the podcasters didn't think that the Carlin estate would immediately respond with a lawsuit, right? Not all these types of uses end up in court. And so maybe the filing of the lawsuit kind of jolted them into realizing that the Carlin estate was serious about protecting his voice and his copyrighted material. Because certainly I think some other artists have been a little bit more welcoming of the experiments around AI, or at least they might have reached out to the producers first and said, hey, can you tell us more about this? This wasn't authorized. We're a little upset about this. In which case, maybe the comedians would have gotten an opportunity to explain themselves and explain that it was a big joke. But, of course, the Carlin estate actually immediately proceeded to a lawsuit, and I think that probably caused the comedians to come clean.
A lawyer for Carlin's estate says the lawsuit is going ahead despite this new claim by the defendants. Quote, we don't know what they're saying to be true. What we will know is that they'll be deposed, they'll produce documents, and there'll be evidence that shows one way or another how the show was created. So, full speed ahead.
Yeah, I mean, and, of course, lawyers say these things. This stunt generated a lot of publicity. It's unclear how much money was actually generated from this. And if it so comes out that even if some amount of evidence is willingly produced that shows that there was actually no copyrighted works that were ingested into any kind of LLM, then the potential damages that the plaintiff can receive just basically evaporate. So in that case, the parties will probably settle, or the plaintiff will voluntarily dismiss the lawsuit. To bring a lawsuit like this all the way to the trial or fact-finding stage where there are depositions and there's discovery is an incredibly costly endeavor. And if what the comedians are saying is true, it would behoove them or would do them well to immediately try to ward off that expensive fact-finding by producing some amount of evidence to show that, in fact, there was no AI training involved. And certainly I think that's been the complaint against a lot of this training data that's been fed into the LLMs is the very opacity of the system, and that it's never clear. Then the plaintiff has no visibility into what the defendant is doing, what their process was, what materials were actually fed into the LLM. This is true not just of the comedians, but of course of large companies like OpenAI. How are you to figure out what OpenAI was training their LLMs on? It's all proprietary. That's been always one of the big complaints from the plaintiffs. And so in those cases, you want discovery to force the company to produce evidence. But in this case, these are two individual comedians. I think the amount of money at stake is vanishingly small if they are able to produce some evidence that this material was wholly original written content.
One AI lawsuit down. Who knows how many more to come? Thanks so much for being on the show. That's Xiyin Tang of UCLA Law School. In other legal news today, a Delaware judge has struck down Elon Musk's $55 billion pay package at Tesla. The decision means that more than 5 years after Musk was granted the largest executive compensation plan in history, Tesla's board will have to start over and come up with a new proposal. Following a trial that started more than a year ago, Delaware Chancery Court Chief Judge Kathleen McCormick sided with an investor who complained that the 2018 package didn't have proper disclosures about the performance benchmarks required of Musk and that the board had conflicts of interest in approving it. The judge wrote, in the final analysis, Musk launched a self-driving process, recalibrating the speed and direction along the way as he saw fit. The process arrived at an unfair price, and through this litigation, the plaintiff requests a recall. The ruling leaves the future of Musk's fortune in limbo. Worth some $51.1 billion, the options were one of his most valuable assets. Without them, his net worth would drop to $154.3 billion, making him the third richest person in the world, after spending most of the past couple of years at number one, according to the Bloomberg Billionaires Index. It's the second legal loss for the billionaire in court. In May, he failed to persuade an appeals court to release him from a 2018 agreement with the U.S. Securities and Exchange Commission that his Twitter posts about Tesla be screened. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And attorneys looking for legal research? Whether you're an in-house counsel or in private practice, Bloomberg Law gives you the edge with the latest in AI-powered legal analytics, business insights, and workflow tools. With guidance from our experts, you'll grasp the latest trends in the legal industry, helping you achieve better results. For the practice of law, the business of law, the future of law, visit BloombergLaw.com. I'm June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.